Imagine this. You waited years in the green card backlog. You attended every interview. You submitted every document. You paid every fee. And then one day, you opened your mailbox and found the approval notice. Your green card was approved. You held it in your hands. You felt safe. You started building your life in America. You bought a home. You changed jobs. Maybe you even started the naturalization process. And then, in April 2026, you see a headline that makes your stomach drop. USCIS is going back and revetting every single green card and immigration benefit that was approved during the Biden administration. The government is reviewing whether it should take your green card back. Not future applicants, not pending cases. Your already approved green card. The one sitting in your wallet right now. This is not a rumor. This is not speculation. This is a confirmed policy announced publicly by USCIS Director Joseph Edlow himself. And on April 22, 2026, 10 United States senators sent an urgent letter to the Government Accountability Office demanding answers about exactly how far this revetting campaign has already gone. What I am about to tell you in this video could determine whether you keep your green card or lose it, so do not skip a single second. Let me start with exactly what was said and who said it. USCIS Director Joseph Edlow stated publicly, and I am quoting his words directly, "We are going back and revetting cases for people who were granted green cards and granted other benefits during the Biden administration, when there was no vetting. There's vetting now, and we're looking at these old cases, so be prepared to face the consequences." He then added, "In terms of the people that are perpetrating fraud, stop, because we are going to find you. And even if you think you've gotten away with it, we're going back." USCIS also posted on their official social media accounts that under the leadership of President Trump, Secretary Mullen, and Director Edlow, the agency has declared what they called a full-scale war on immigration fraud. They confirmed they are revetting cases for people who were granted immigration benefits during the Biden administration, and that individuals who committed fraud should be prepared to face the consequences. The agency is also preparing to open multiple tip lines to allow anyone to report suspected immigration fraud. That means your neighbor, your coworker, your ex-spouse, or anyone else could file a tip about your case. Now let me give you the numbers so you understand the scale of what is happening. During the Biden administration, approximately 4.8 million green cards were issued across fiscal years 2021 through 2024. In FY 2021, about 740,000 green cards were issued. In FY 2022, about 1.01 million. In FY 2023, about 1.17 million. And in FY 2024, close to 1.4 million, which was a 92% increase compared to FY 2020. Every single one of those cases is now potentially subject to a second look by USCIS under the current administration's revetting initiative. But this is not just about green cards. The revetting covers all immigration benefits approved during that period. That includes asylum grants, refugee admissions, temporary protected status, employment authorization documents, naturalization approvals, and diversity visa adjustments. If you received any immigration benefit between January 20, 2021 and January 19, 2025, your case could be reviewed. Let me now walk you through the 3 specific policy actions that make this revetting legally operational. On March 30, 2026, USCIS issued a public alert titled, "Update on USCIS's Strengthened Screening and Vetting." In that alert, the agency stated that prior screening and vetting measures were, in their words, wholly inadequate, and that many applicants for naturalization and lawful permanent residence were not sufficiently vetted. As a result, the agency said, applications were approved and individuals were naturalized who should not have been. This alert was built on 3 policy memoranda that USCIS had already issued. The first, PM 602-0192, issued in December 2025, placed on hold all pending asylum applications and all benefit applications filed by individuals from high-risk countries. The second, PM 602-0193, issued in December 2025, placed on hold all pending diversity visa adjustment of status applications. The third, PM 602-0194, issued on January 1, 2026, expanded the hold to benefit applications from additional high-risk countries. Together, these memoranda affect nationals from 39 countries plus the Palestinian territories. And then there is Operation PARRIS. In January 2026, USCIS launched what it called a landmark fraud investigation in Minnesota. Operation PARRIS, which stands for Post-Admission Refugee Re-Verification and Integrity Strengthening, targeted approximately 5,600 refugees in the Minneapolis-St. Paul area who had been admitted but had not yet adjusted to permanent resident status. Under this operation, USCIS and ICE were authorized to arrest, detain, and re-interview these refugees. A February 2026 DHS memorandum confirmed that this authority applies to any refugee who has lived in the United States for at least 1 year and has not yet acquired lawful permanent resident status. Now here is what makes this even more alarming. According to the Senate Judiciary Committee's April 22, 2026 letter to the GAO, when Operation PARRIS re-interviews were resulting in too many refugees being reaffirmed as legitimate, White House Deputy Chief of Staff Stephen Miller reportedly hand-picked lawyers to personally review those results. The senators described the entire re-vetting effort as potentially a pretext for targeting immigrants and naturalized U.S. citizens for unwarranted scrutiny and selective enforcement, rather than a legitimate exercise in reducing fraud. So who exactly is most at risk right now? Let me break this down into 5 groups. Group 1 is refugees who were admitted between 2021 and 2025 and have not yet adjusted to permanent resident status. They face the highest immediate risk because USCIS has already demonstrated through Operation PARRIS that it will arrest and detain people in this category for re-interviews. Group 2 is green card holders from any of the 39 banned countries, plus the Palestinian territories, who received their approval after January 20, 2021. Their cases are subject to the policy memoranda holds. Group 3 is diversity visa lottery winners who adjusted status during the Biden administration. Their applications are specifically targeted by PM 602-0193. Group 4 is anyone whose green card was based on a marriage, employment sponsorship, or family petition, where there are any inconsistencies in the record. The new enhanced vetting includes increased social media screening, financial vetting, and community interviews. Group 5 is naturalized citizens whose underlying green card was obtained during the Biden era. Under the law, if USCIS rescinds your green card, your naturalization can also be revoked. Now let me tell you the legal process that USCIS must follow if they decide to act against your case, because understanding this process is your most important protection. Under current law, if USCIS believes your adjustment of status was not proper, they must serve you personally with a notice of intent to rescind within 5 years of the date your green card was approved. Once you receive that notice, you have 30 days to respond in writing. You have the right to present evidence, submit affidavits, and explain any discrepancies. If USCIS is not satisfied with your response, they issue a final rescission decision, and if you challenge it, the case goes to immigration court where a judge decides. This is not an instant process. They cannot simply cancel your green card overnight. You have rights at every step. But you must exercise those rights, and you must exercise them with the help of a qualified attorney. Here is your 7-step protection plan. Step 1. Gather and organize every document related to your immigration case right now. That includes your original petition, approval notices, interview records, tax returns, employment letters, marriage certificates, and any correspondence with USCIS. If something in your file has an error, it is better to identify it now than to be surprised during a re-review. Step 2. Do not ignore any communication from USCIS or DHS. If you receive a notice of intent to rescind, a request for evidence, or even a letter asking you to appear for a re-interview, respond within the deadline. Missing a deadline can result in automatic adverse action. Step 3. Consult an immigration attorney immediately, especially if you are from one of the 39 high-risk countries, if your green card was based on a marriage that has since ended, if there is any discrepancy in your employment history, or if your refugee status is being reviewed. Step 4. Do not volunteer information on social media. USCIS has confirmed that enhanced vetting now includes social media and financial screening. Review your accounts. Remove anything that could be misinterpreted. Step 5. If you are a green card holder and eligible for naturalization, talk to an attorney about whether filing your N-400 now makes strategic sense for your specific situation. Step 6. Keep records of your physical presence in the United States. USCIS is increasing scrutiny of continuous residence and physical presence requirements. Travel records, lease agreements, utility bills, and tax filings all serve as evidence. Step 7. Do not panic, but do not be passive. The legal standard for rescission is high. USCIS must prove that you were not eligible at the time of approval. If your case was legitimate, the evidence is on your side. But only if you have it organized and ready. Let me close with this. Between 2021 and 2024, nearly 4.8 million people received green cards. The vast majority of those cases were legitimate, properly vetted, and lawfully approved. But the current administration has made it clear that it intends to review a significant number of those cases, and the infrastructure for doing so, including the tip lines, the vetting center, the policy memoranda, and the Operation PARRIS framework, is already in place. This is not about causing fear. This is about making sure you are prepared. Knowledge is your greatest protection, documentation is your shield, and a qualified attorney is your strongest ally. If you found this video helpful, subscribe to this channel right now and turn on the notification bell. I cover every immigration update the moment it happens. Share this video with every green card holder you know, because this information could protect their status. Drop a comment below telling me when your green card was approved and whether you are concerned about the revetting, and I will keep this community updated as new developments come in. And please remember, everything in this video is for educational and informational purposes only. This is not legal advice. Every immigration case is unique. For guidance specific to your situation, please consult a qualified immigration attorney. Your green card is worth protecting. Start today.